Hi, and welcome to the ITPro Podcast. I'm Jane McCallion.
And I'm Adam Shepherd.
Now, to say that 2020 was a tumultuous year would be underselling it a little bit. At a global level, we had the nail-biting US presidential election and, of course, the COVID-19 pandemic, to name just two. More locally, 2020 also marked the last year of the Brexit saga, in its current form anyway, with the country officially leaving the European Union in January and the transition period ending in December.
With our EU membership behind us, UK organisations now have to start wrestling with the adjustments they may need to make in order to remain legally compliant in a post-Brexit landscape. The use of data as a commodity has become even more important now than it was in 2016 when the country voted to leave. But how will Brexit impact the ability of companies to capitalise on their data assets? And in particular, how will it affect the transfer of data across international borders?
Joining us to discuss the ramifications of data transfer in a post-Brexit world is Bart Willemsen, VP at Gartner, specialising in privacy. Bart, welcome to the show.
Good day, thanks for having me.
So, Bart, Brexit presents a number of challenges for organisations. One of the biggest being the new relationship that UK organisations have to grapple with in terms of borders, but as well as the transfer of goods, the transfer of data is also something that has come up a lot over the course of the last couple of years in these discussions. What are the main types of data that organisations need to be thinking about when they're looking at cross-border transfer?
Well, primarily we're talking about personal data. Most of the legal implications come from the background of the European Union's GDPR and such. What's important, however, is to realize what is personal data then? In my conversations with companies in the APAC regions or some areas in the US still, the talk around that is mostly about PII and has a much narrower view, focusing mostly on directly identifiable information, name, address, email, phone number, social security number, etc. From a risk perspective, it really is time to acknowledge that much more data than that set of 2-3 dozen of directly identifiable types brings with it privacy risk. This is, for example, now clear in many discussions around the upcoming WhatsApp policy changes that were announced. A lot of metadata seems to be shared soon, more than before, with the Facebook family of companies. Although they're in published FAQs and whatnot, focused now on promises that continue to ensure that the content of conversations and instant messages will not be shared, actually matters little. With the abundance of information that Facebook already has on internet users, more so even on those without a profile probably than on those who actually are a Facebook member, it may not be that difficult for them to re-identify who's who based on metadata gathered from WhatsApp. So who contacts who, for how long, at what times, enriched with things like signal strength, location information, type of connection, etc. All such information brings privacy risk to the individuals with it. Back to the question on cross-border transfers, in short, all personal data must be considered at least, and that includes, as definitions go, all information that directly or, mind you, indirectly identifies or, and there it actually comes, assists in the identifiability of an individual. That's a lot. Let's be clear, it's not only about customers, or if you're a government entity, about citizens. It's also about employees, what they do in applications, in systems. See, for example, the discussion around Microsoft harvesting telemetry data on Office 365 back in 2018 and 19. In essence, it's our responsibility to protect the data on all individuals. That's preferably first and foremost from an ethical perspective, at least when it comes to how we look at processing personal data across the entire life cycle. If that's not enough, yes, we have applicable regulations to help us out, like GDPR in the EU and its sibling in the UK, the Data Protection Act of 2018. They're mostly similar, but on the position of cross-border transfers, some differences are now becoming clear, I'd say.
So I just want to drill down quickly into something you just mentioned about the use of data by organizations to kind of monitor employees and kind of track employee behavior, because that's something that organizations over the last couple of years have been investing quite heavily in terms of, for want of a better term, intra-organizational analytics. So looking at how employees use internal tools and internal platforms to drive, more efficiencies, to track timesheets, that kind of thing. Is this something that organizations are kind of aware of the data privacy risks around, do you think?
Not entirely sure. If we look at what happens now, in the whole situation around COVID, how we respond to it, the increased remote work set of situations, some organizations are actually inclined very quickly, without much consideration, to add a number of monitoring technologies. It's been seen, by the way, as not the ideal way to go. Yes, in a number of surveys, we see that close to a third of organizations are actually covertly, or maybe not covertly, without too much impact on the actual work, monitoring employees. Some have actually shifted to using, for example, laptop log on and log off moments as a pure security log to suddenly reuse that instead of a punch clock. Many would consider, is that even legal? Is that the right way to go? Studies are starting to show that remote working leads actually to productivity increase. People are working more hours, not commuting, etc. They tend to be more flexible. And in fact, it has been shown that through some experiments in the past, if you provide extra privacy to an employee, they may be up to 15% more productive. Whereas other studies have shown that if employees feel that their privacy is really out the window, and some have experimented with visual monitoring, full screen video capture, that sort of thing. If the individual knows that, productivity may in fact go down as much as 50%, 50. So I'm not sure that full-blown monitoring is the way to go. We do see that people are getting much more creative, very innovative, responding very well in most cases to this new situation, temporary as it may be. We're all trying to find ways. From a company perspective, again, one of the golden rules would be if it wasn't necessary in the conventional office space, and there's no reason to expect otherwise. Ultimately, an impact assessment would probably, tell you or justify whether or not certain additional measures are necessary. But if it wasn't part of the previous life, consider very detailed whether or not it should be part of this remote working situation.
Can I actually quickly jump back to something that you said as well before we move on to what all of this means? So you're talking about the importance of metadata. And I think clearly the tech giants, be that Facebook, be that Microsoft, Google, whoever, they understand the importance and value, if you like, of metadata. In fact, that's got to be one of their biggest kind of assets, if you like, the data mining that they can do on that. Do companies who are not in that sector really understand what metadata is and why it's so important? Because that must have an impact when we're talking about cross-border data transfer as well.
Increasingly, they understand the relevance. Unfortunately, most of the time, that discussion is spurred by accident. If something goes wrong, many analogies have been made. What can one do with metadata? And you can get very creative there. In essence, the point that we have to focus on is what is the level of privacy risk, whether it's directly identifiable, indirectly identifiable, in itself not identifiable at all. It doesn't really matter. We have to look at what is the risk of the data. Number one, no organization exists to process data, personal data specifically. We process such data to exist. If we acknowledge that, then we should also acknowledge that data should serve a purpose. Data that no longer serves a purpose does nothing for us but quietly sit in the corner and accumulate risk as time progresses. Time being a critical success factor to a data breach, one might say. Those hurt enough already. And if data gets breached that we have no excuse for as to why we had it in the first place, that will hurt infinitely more. So better try to prevent that. And organizations are coming to terms with that more and more, cleaning up the dirty attic, so to speak. Although over the course of the last few decades, most of us have behaved like those proverbial hoarders. Who knows what it might be good for later on. And when things go wrong, yes, then that's where we see that it's not just about directly identifiable information.
So turning now to the rules of cross-border data transfer, what were they prior to Brexit between the UK and the EU and elsewhere?
There's a bit of a history there. Prior to Brexit, the UK was obviously one of the then 28 member states of the EU family, right?
Mm-hmm.
As such, the GDPR, as of May 2018, formally applied to all member states. When it comes to where is data allowed to be, the rules were pretty much universal for all member states. The world, from an EU perspective at least, is sort of layered, so to speak. I sometimes still have to explain this across certain oceans, but in general, we all know that the EU is not a country, right? Rather a family of countries. As in every family, we laugh and we fight sometimes, but in general, we tend to trust each other to a certain level based on, common rules. In this case, GDPR. That's why, first of all, personal data can flow freely across member states. At the time, there were the additional EEA members of the European Economical Area, Norway, Liechtenstein, and Iceland. They got married into the family, so to speak, adopt the same rule book. Then there was another layer, a short list of countries, I believe 12 at the moment, who have what's called an adequacy decision. In essence, the European Commission has looked at the national data protection provisions in those countries and concluded that it was sufficiently adequate to what the EU envisioned at the time. As a result, data can flow freely to and from those countries as well. Then there is the rest of the world, so to speak. There's some countries who seem to take a national approach, like Russia, China, I believe even Uganda, Malaysia, and rather soon, through the upcoming Personal Data Protection Bill, India. All of these countries basically say that personal data can, on principle, in many cases, not leave the geographic borders of that country to begin with. Aside from that, for countries not in the first three layers, so to speak, additional protection measures are necessary both on a governance level through standard contractual clauses for external transfers, binding corporate rules for transfers within global international organizations, but also on a technical control level, for example, through encryption. By the way, the principle of having to conduct a detailed data protection impact assessment applies universally. So in every processing activity that there already was and still is the responsibility to look at the various risks, the ins and outs of that particular processing activity, regardless of where the data sits, where the iron buzzes to contains the bits and bytes, so to speak. It had to be assessed already, fitted with adequate security measures, and that part doesn't change. What also hasn't changed is, again, we have to remember what constitutes processing of personal data. The understanding of that is the same in the UK as it is in the rest of the EU. It's not just creating it or storing it, it's also transferring, the actual act of anonymizing data, or actually deleting it, even showing it to a screen on a tablet in Singapore, for all I care, while the data resides in a data center in Ireland. All of this is considered processing and covered by things like the GDPR. So before Brexit, those were the layers.
And so, things, let's say that they came to a head rather last minute, just before Christmas, but we all got a little present, which is some vague kind of agreement, as messy as it may be. How have things changed for data? Because I can't imagine that it's quite as drastic or the scenario with goods in particular, also services to a lesser extent, is not ideal. What has the impact been on the data side of things?
Well, some of them have actually changed a little earlier than indeed the transition period ending. It may be important to first understand what happened, disregarding Brexit on July 16 of 2020, the infamous Schrems II ruling of the Court of Justice of the European Union. They basically decided that, for various reasons, that the United States did not provide adequate protection of personal data and almost collaterally invalidated the transatlantic gentleman's agreement that we had called Privacy Shield. That at the time already scrambled many of our clients to look into alternative protection methods or redirect some data flows internationally. If we look at those relations first, and I will come to a Brexit point,
Mm-hmm.
European Data Protection Board, the EDPB, strongly emphasizes since Schrems II the need for impact assessments of the destination country before we decide to send data out of the European Economic Area. There's a specific focus on the extent to which confidentiality of data can be guaranteed. When the assessment shows that there's insufficient guarantee, resulting advice may be to not execute that transfer. The point is, it's not just regarding the US, it's regarding every country outside the European Union without an adequacy status. That may have implications on how to deal with service providers who, even though they're not servicing you from within the US, are subject to US regulations.
Yeah.
There are opportunities under the recent US Cloud Act, which has little to do with cloud computing, but stands for Clarifying Lawful Overseas Usage of Data. What's in a name? Now, under the Cloud Act, countries can enter into an MLAT, a mutual data sharing agreement. The UK and the US have such an agreement, and the UK has similar arrangements with other jurisdictions like Australia. Now, enter Brexit, right? The UK may have adopted GDPR, so to speak, in the Data Protection Act of 2018, but it's not really a copy-paste exercise. Why is this important? Look at Schrems II and the situation of the UK currently. The Committee on Human Rights in the past have openly expressed their concerns as to whether there is a conflict with the CFR, the Charter of Fundamental Rights. There are exception situations, for example, where privacy rights are lifted in the UK in immigration control processes, for example. The European Commission in the past has also said that before the transition period ended, that the UK would probably primarily be observed as any other country without an adequacy decision. In theory, they can receive the status. It's considered by some privacy professionals rather unlikely, though. Even when the Commission grants it, the Court of Justice can still very well overrule that. In the past, the Court of Justice has already stated that the UK's data protection guarantees are, at the time, not adequate under GDPR. There have been lots of speculations on the future of data flows after Brexit. The feeling in general, among clients that I speak on the topic, is that something will specifically have to be done about the UK Investigatory Powers Act in order for adequacy to be approved. In essence, the existence of the UK's, I believe you call it, Snoopers Charter, is also considered in contravention with the CFR. However, there's a meantime measure in place, right? A temporary decision. You mentioned it. In my opinion, doesn't necessarily do more than postpone a fierce debate and potentially painful need for the courts to get involved again. But the recent announcement came that after the end of the transition period, they allow transfers between EU and UK for a few more months. I believe maximum extension to 6 months. Temporary deal has a few provisions. UK, for example, is not allowed to change the current data protection legislation. They also can't enter into new data sharing agreements with other countries, but pending an adequacy decision, the existing agreements with the US, with Australia, with others, may already be enough reason to expect that debate will not be finished in those 6 months.
Yeah.
Well, it's time for us to take a short break now, but when we come back, we'll be looking at the changes that organisations may need to put in place in order to remain compliant with UK laws.
See you after the break. Welcome back. So, Bart, before the break, you mentioned Privacy Shield and how the Schrems II ruling had ruled that once again it wasn't adequate. And the reason that I say once again is, of course, that was the successor to Safe Harbour. Now, this backward and forward between the EU and the US and the fact that these agreements keep being found to actually not be adequate in the eyes of the EU, at least, does this give us an indicator of just how difficult it's going to be for the UK to actually come up with a proper working solid agreement for data transfer between it and the EU?
It's a good question. And opinions on that have greatly changed and shifted left and right over the course of the last 6 to 12 months. In the advent of Brexit, we have looked frequently to what are the US relations. What if the UK post-Brexit would not get an adequacy standing? Would there be an opportunity for a copy-paste of something like Privacy Shield? not just across the Atlantic with the US, but across the North Sea with the UK. It was highly unlikely. And I believe with the invalidation of Safe Harbor, 2000, what was that, 15, 16, um, at the time, we saw a different position. Many of my clients were calling about that as well at the time. And at the time, it was clear that regulatory authorities were like, okay, we won't slap you on the wrist immediately when we see that you haven't shifted or that you haven't done anything about this within a day of its invalidation. Let's take some time. We're working on an alternative. And not much happened there. Meanwhile, we did advise clients, this is not stable. It's the least stable of all mechanisms. So by all means, if you can, move to binding corporate rules, move to standard contractual clauses instead. Whatever the alternative arrangement is, it is eventually nothing other than a gentleman's agreement between two entities. It's not a law, let's be honest. Of course, Privacy Shield came around, yes, now invalidated, but the standing of the regulatory authorities was also considerably different. They didn't say, don't worry so much, don't jump up and down. We'll work on an alternative pretty soon. Nothing of that. And rightly so, because for years we've said, again, it's the least stable mechanism. Around, I believe, 2,500 service providers at the time self-certified for the Privacy Shield framework. So, yeah, I don't expect an alternative anytime soon. If it does come there, I will continue to say the same. 2015, the situation might have been a bit different. Standard contractual clauses were not so old. GDPR wasn't there yet. 2016 consultation rounds of GDPR, we already saw coming that whatever was the Privacy Shield, it would have a bit of difficulty after GDPR would kick in. And to be honest, standard contractual clauses for extra organizational transfers outside the organization, they're older than the iPhone or companies like Facebook and Netflix. I believe the first one is from 2001, the second from 2004. Okay, granted, the third one is from of 2010, if I'm not mistaken. But they were up for revision anyway. GDPR kicking in 2018, we expected that SECs would be very quickly aligned with that. But, everybody had other things to do, reprioritization, etc. If anything, the Schrems II ruling has expedited the review of standard contractual clauses. The consultation rounds on that closed shortly before the holidays. And we do expect anytime soon for them to come up with a definitive version. Back to the situation of the UK. I do not expect that there is even an opportunity, a reasonable opportunity for a future-proof, a sustainable, like I said, gentleman's agreement that is not a fixed agreement outside an adequacy standing.
So, given the, shall we say, precarious position of UK data protection legislation and the various international agreements that still are up for discussion and need to be finalised, what preparations can UK organisations put in place now in order to remain compliant in the future, or at the very least make compliance more feasible?
That's probably the point where I have to stress that, I'm not a lawyer, so my company is not a law firm. We can't say what's compliant and what's not. Ultimately, the line in the sand lies there where any organization's legal representation says that it lies, to where they feel comfortable defending somebody's position, right? If anything, by the way, in my many interactions over the past 6-7 months, it's become clear that such a line is not fixed. It can be in various different places. And there's certainly a number of best practices and increasingly popular trends, some because of regulatory guidance, like by the European Data Protection Board, some on a more technical level. The first thing would be, keep the finger on the pulse, really monitor developments, because this has the propensity of going into a variety of directions. It greatly depends on how much water the UK is prepared to add to the, let's call it GDPR flavored wine, so to speak. If in favor of probably most international geopolitical and economical reasons, the UK is about to water down the content or the interpretation or even the enforcement of current data protection framework, an adequacy decision is getting more and more unlikely. What to do now? Well, first, transfer impact assessments. Where is the data processed or even potentially accessible from? don't mind the law as much as your own risk appetite, I'd say. The company's own risk appetite might actually be lower. You may decide to have a more strict or rigorous approach to where data is potentially accessible from, where it is stored to begin with. But realize that from an EU perspective, the UK may become observed as less safe unless you can prove otherwise. They'll likely also add encryption, other in-use protection mechanisms. From a UK perspective, I'd say focus primarily on the data protection impact assessment. Note that existing regulation framework is principle-based rather than rule-based. That's actually a good thing. As such, data protection impact assessments should be revised frequently. Look at technical protection, for example. Say that you were a web shop or an online platform in 1999. If at the time you would start your business online and you do such a DPIA, you would look at, okay, well, our users have usernames, passwords for logon. Passwords. Yes, that's sensitive information. We may have to do something with that. And then somebody smart stood up from the security group and says, let's hash them. Yeah, good. We use MD5 as a hashing method. In 1999, you'd be perfectly all right. However, if you never revisit that decision, that impact assessment, you'd still be using that in 2021. Now, we all know MD5 got broken, dead as a doorknob since 2008. It's been used in the Flamewell malware attack of 2012, and frankly, any 7-year-old who can watch a 3-minute YouTube video or find the right URL can reverse engineer almost anything. That's why today we at least randomly sort our hashes using SHA-256 or 512. But same today. Look at what is an adequate, fitting technical set of measures at the risks that you are running, mainly focusing on the confidentiality of the data. The technology reliance depends on use cases. For example, we see tech providers, Microsoft in their Azure environment, offering confidential computing using secure hardware enclaves, basically encrypting the data in use. AWS is dabbling with it. Google is mentioning it every now and then. From an end user perspective, however, mind who is in control. The rise of CASBs, Cloud Access Security Brokers. It's a market that does exactly what the name says. They broker access security to the cloud. That's really adoption increase. I believe my colleagues who cover that market are calling for a compound annual growth rate of it of well above 40% for the next few years still. It's an unprecedented growth. I believe that the market was estimated at around 720 million US dollars, that is, in 2017, beginning of 18. At the time, the CAGR, the annual growth rate, was projected to be about 40% year over year through 2022. And meanwhile, we were really on point because it has been growing like that. And the projection is extended through 2023 and even now added a few percent to that. To me, that says that increasingly organizations do not wish to solely rely on the big brown Bambi eyes of the primary service provider, but need additional assurance. Very long term, yes, there are those who talk about, for example, the European Sovereign Cloud Initiative, Gaia-X. For now, I'd say that is nothing more than a strategic consideration long term. It isn't there yet. I believe the architecture and framework is about to be finished. They haven't started building. I believe the Europeans have said that they would invest about 10 billion euros over the course of the next 7 years. Sounds like a lot. Until you realize that, I believe AWS's 2021 cloud investment budget is a multitude of that single digit.
I was going to say that's only just over $1 billion a year, which that's a lot of money for me and you, but it's not an awful lot of money at a national, supranational, or even large corporate level.
Absolutely. Hence the addition. It's good to keep a finger on the pulse on these developments. There's a lot of innovation going on here in various levels of maturity. Most of the privacy-enhancing computation techniques are really out of the academic realm and increasingly applicable, increasingly available. I wouldn't look at affordability as much, but that's also something that is moving very well in the right direction. Why do I say I wouldn't look at that too much? Because regulatory authorities in the past have been known to say, well, if you cannot protect, you shouldn't collect, saying
Mhm.
the price of a countermeasure should not be the decision to not apply it. But other than that, these things are really becoming more and more viable and therefore reasonable alternatives in privacy impact assessments or data protection impact assessments.
So ultimately, we've got a grace period of a couple of months, really, for UK companies or companies doing business in the UK. Are they going to be okay? Are they prepared to handle these challenges, or are we going to see some kind of data equivalent of fish and pork and stuff rotting in lorries as we wait for the data to get across the borders?
I'm very hesitating to now envision what you just said, but I like the analogy. No, I really like the analogy. How prepared? Unclear, but I'd say initial assessment, not very. I'm fielding a considerable amount of client calls on this, but most of them are starting to investigate at best, rather than they're almost done with implementations and asking about details of how things can be completed. Implementing these large changes is something that is usually not a matter of weeks. On the other hand, let's be honest, we all understand that this is major impact. And we shouldn't necessarily do this because of the fear of what might a regulator say pretty soon. I always maintain things like GDPR are the same as speed limits. You drive on a motorway and there's a sign next to the road and says, you can drive here, but thou shalt not exceed 55 mph. Why do people still speed? It's not about the chance of getting caught by the police. It's also a matter of, it should primarily be a matter of risk-based approach. By the way, if there was 3,000 people come in front of you to a full stop in a traffic jam, what, we still maintain 55 because the sign says we're allowed to? Of course not. In real life, we understand this. So why is it that when it comes to personal data, which is actually digital traffic and just as well can bring harm in case of an accident to individuals, why is it that we forget that in digital life, in professional life? About preparation, it is as important to have a decent, detailed plan with milestones that you say, okay, we know this or that change takes about 10 to 12 months. Okay, so it exceeds that grace period that we have now. So what? As long as you can demonstrate that, we've achieved the milestones as we set them out and we know what the next steps are. We are busy with that. And upon completion, we're good to go. We give it the right priority. That's as important as doing the right thing to begin with. Mind the guidance provided internationally as best practices so far, number one. Number two, again, I said this before, this is more about an ethical approach to data protection as it is about legal compliance. Considerable, adequate assurance on data, primarily on confidentiality, should be key. Exclusion of operations is not an option, nor is pure isolation, let's be honest. So there are risks there, but in the long run, we're really called to apply in-use protection mechanisms. Mind the law, yes, but only as a fundament of your holistic personal data lifecycle governance or management, if you will.
Well, unfortunately, that's all we've got time for this week, but our thanks once again to Gartner's Bart Willemsen for joining us.
Well, many thanks for having me. Thanks for your time, and to everybody who's listening, stay safe.
Thank you. You can find links to all of the topics we've discussed today in the show notes, and even more on our website, www.itpro.co.uk. You can also follow us on Twitter, where we're at ITPro, as well as Facebook and LinkedIn, or get in contact via email, where our address is podcast@itpro.co.uk.
Don't forget to subscribe to the show wherever you listen to podcasts, and if you can, leave us a rating and a review.
We'll be back next week with more insight and analysis from the world of IT. But until then, goodbye.
Goodbye. The ITPro Podcast is brought to you by the Dennis Podcast Network.